All right, everybody, welcome back to another episode of Unfiltered HR. No, that is not Jen sitting next to me visually here today. It is Heather Giambra, a good friend also in the employment superhero space, I'll call it, I guess. So Jen is a busy lady, and so she could not join us today, but we have Heather here. And Heather, if you want to take a moment to introduce yourself, that would be awesome.
Sure. My name's Heather Giambra. I work with Emily quite a bit. I'm a labor and employment lawyer, a management side labor and employment lawyer. My firm is Schroeder, Joseph and Associates here in Buffalo, New York, and I help Emily with all things labor and employment related. So when she gets a more complicated question or something out of the ordinary, or just wants someone to bounce something off, she calls me and we talk through things and we commiserate about, the stressful life of labor and employment practitioners in general,
Employers, yes,
complying
yeah.
complying with all of the laws and regulations that there are for employers to comply with. So yeah,
Yes.
but I'm happy to be here, and I'm looking forward to talking with you all about what's going on at the National Labor Relations Board and union organizing, and what employers need to know and do when the union comes knocking.
Yes, yes, and that's a good point. So, Heather, whether it's the topic we're going to talk about today, which is organizing efforts and kind of the new age of union activity and rights, especially in the past few years with the Biden administration and what's gone on, whether it's that topic or anything employment, HR related, I'm kind of the prophylactic and the supplement to make you kind of healthy and not get sick, maybe we could call it. And Heather and her team are who I refer my clients to often when you are facing a DOL claim or a lawsuit or something is more serious and it really rises to the level of a matter that needs to be dealt with by a law firm and legal services. So, thanks Heather for all that you do on that side.
Glad to help.
All right, so today, Heather and I have spent many a time off camera talking about this subject. But today we wanted to talk with you guys about the state of union activity. And of course, we're all living here, at least Heather and I are here. And maybe if you're listening here in Western New York and Buffalo, where this has been a hot topic in the news for a lot of reasons, but kind of unionization activity. Not only is there more of it kind of in the news and in real lives of employers, again, especially here in Buffalo, but nationally, which is all these laws and regulations are kind of passed and determined at the federal level. Nationally, there's been a lot of activity in kind of changing and redefining of the rights of employers and employees when it comes to organizing efforts and unionization and that kind of thing. So that's what we're here to talk about today because it is significant and it is certainly affecting employers, even those that really have never had to deal with it before, more than ever. So Heather, I'm sure you guys have gotten a lot more questions and your business has probably increased in this area, right? In the past couple of years.
So it's interesting because employers often think, "Oh, I don't have a union. My shop is not unionized. My business isn't unionized. I don't need to worry about that. I don't need to know anything about the National Labor Relations Act or what's going on at the board because those things don't apply to me." And that's a really big misconception that employers have. So the law actually applies to all employers, whether they have a union or not. It guarantees employees various rights to engage in certain activity, and they don't have to be unionized to engage in that activity. I mean, one of the main rights that the law does give is for employees to join together and form a union, but it also gives them the right to, just oppose other things jointly, even without a union. And so there are a number of things that in the law that apply even to non-unionized employees. And more recently, I'll say in the last couple of years, there have been a lot of things like work rules. Employees can have work rules. Non-union employees can have work rules in their handbook that the National Labor Relations Board might think interfere with employees' right to unionize. They think certain work rules could chill employees in the exercise of their union activities. And so you don't have to have a union to have a bad work rule that would run afoul of the National Labor Relations Act. Other things such as having confidentiality provisions and employment agreements for relatively entry-level employees, people who are not really going to have access to your highly confidential information. And even in businesses where it's unlikely that you have any highly confidential information,
Mm-hmm.
some employers have employees routinely sign these agreements, and the National Labor Relations Board, among other regulating agencies, have said that that's an unlawful practice, that you're interfering with employees' rights by asking them to keep information confidential. These overly broad provisions could cause them to believe that they're not allowed to talk about their pay with other employees. The same goes for like non-disparagement provisions that employers might put in um, severance agreements or
Mm-hmm.
employment agreements. The board says that employees have to have the right to talk about their employer, good or bad. And so
Mm-hmm.
including those types of provisions in those agreements can get you in trouble, whether or not you have a union. So I think that's the first thing. And unfortunately, we don't get the questions because people think, I don't have a union, so those laws don't
I don't have
apply
to
to
worry about
me.
it. Yeah, yeah.
Yeah,
Okay.
but
Yeah,
but
that's a
they
really
really
good point.
do.
Yeah. Yeah. So if you're listening to this and you're not unionized and you think there's absolutely no way that's going to happen to you, that's kind of irrelevant to this information being like helpful and pertinent to you today. Because, yeah, especially recently, the protections have expanded to be, even more relevant to people outside of that realm. So certainly continue to listen on if you're not in that space or if you don't think your space is going to have that happen. um, yeah, I mean, I was just talking to a employer last week, Heather. I get this question quite often. Employees were sharing information about bonuses and about each of their different bonus eligibility and payout, and the employer was pretty upset because it obviously, people are different, eligible for different amounts and got different amounts, and then it causes this, uproar and people coming and asking for more and asking for explanations and, for whatever you think about, being transparent about pay practices and that kind of thing. The client certainly was upset and didn't really want to have that happen. And my answer was, there's not really much you could do about that, right?
Yeah, I mean,
Yeah,
it's their pay. They're allowed to talk about it. They're allowed to tell anyone they want how much you pay them, what you gave them for a bonus. I mean, that is
yeah,
that is one of the essential terms and conditions of employment is pay, and so employees have to be able to share that information with one another.
yeah, yeah. So I think what we want to talk about today was, aside from how kind of the scope of these rules and laws and protections really apply inside and outside of employers that are unionized or employers who have like an organizing effort going on. I mean, that's certainly an important point. But we did want to talk about organizing efforts in general and how the rules around that and kind of the avenues for that have changed so much, especially even just in the last 6 months to a year. And, again, even in a small market like here in Buffalo, we've seen more of it, and we think it's important for you as small business owners or HR people or that work in small businesses or just businesses in general to understand what the new rules and the new landscape is, so that you don't accidentally violate these things, and especially as these efforts maybe enter your workplace. But also, we did want to touch on maybe ways that you could prevent employees from having a feeling of need of even starting organizing efforts in the first place to bring it into the workplace. Because certainly I think everyone would prefer on the employee and employer end to keep kind of that direct relationship and direct line of communication and trust in place, in lieu of having a middleman in the mix. So that's kind of the bulk of what we wanted to cover today. So have some stats here to start out. Just if you don't think this topic is relevant, or you think maybe we're being alarmist about the fact that this effort's on the rise, these statistics hopefully will prove that wrong. But basically, union representation petitions, so petitions by employees who recognize a union within a business. In 2023, those are up 53%. So that's really not a small number. And these are national numbers. Unfair labor practice charges, we'll explain what those are, but that's basically when an employer is accused of violating employees' rights to unionize or related to that. Those were up about 20% in 2023. There's been the biggest rise in 2023 in new union members since 2017. So although union numbers and union membership is on the decline nationally because of just the number of new businesses that have opened up, it's still, there's a greater increase than there has been in quite a long time in union membership. And then most filings in The past couple years, we're in California, only followed by New York, so we're up there. Certainly, we've again seen that locally here in Buffalo as a little epicenter. And then I think the most significant thing I read, Heather, and maybe you've seen this too, and I know we both work in kind of like the small business space, is that smaller businesses, I think this is pretty unique and for the first time ever, but smaller businesses are more likely to confront an organizing drive than bigger businesses at this point. So a large majority of the petitions over the last 3 years have been employers with 50 or less employees. Is that pretty unusual?
Um, I think it's becoming more usual to see that. I mean, I think traditionally when we thought of unionization and we thought of businesses that were unionized, we people would think of, manufacturing facilities that employ hundreds of employees and big companies. And we always hear about, the auto industry and the unionization there. And that's what sort of makes the news. But my experience, I mean, I've got some of those clients that are larger and they've been unionized for 20, 30, 40, 50 years, right? They've been
Mm-hmm.
organized for a long time. But the really where we are seeing the organizing activity is in smaller businesses, and I wouldn't necessarily say 50 or less. There are plenty that are 50 or less, but even 100 or less, like sort of that, you're not a huge employer, you maybe only have, one facility, one location, um, but it's businesses that are not that we aren't necessarily thinking of as traditionally being unionized. And the industries are also industries that we don't necessarily always think of as traditionally being unionized. Obviously, the service industry, there's been a huge surge in unionization there. I think it really started with, the Starbucks campaign, which started here in Buffalo, really garnered a lot of attention. And I think that so service industry everywhere, I think, is seeing that rise
Mm-hmm.
in unionization. Um, I've seen the same. Um, I've got not-for-profit law firms that are unionizing, and there are several not-for-profit legal service providers that have been unionized for a long time, but it seems like those that aren't, they're all unionizing now, and so
Mm-hmm.
we're looking at more sort of white collar workers unionizing, which we're not really that accustomed to seeing other than in the public sector.
Mm-hmm.
Um, and really service industry employees. And that's a big change, especially when we start talking about the service industry, because those are jobs that were typically not really jobs that people were going to be in for life, right? Those are
Right.
jobs that you have while you were in college. Those are jobs that you have them for a little while until you move on to your career, what you plan on doing forever. And now they're starting to organize there. And so um, the what the employees are looking for and what is important to employees is maybe a little bit different there than
Yeah.
what we're traditionally used to seeing, and so it's a change. Things are definitely shifting
Yeah. Yeah.
a bit.
Yeah. Yeah, so that's a good point going into this too before we talk about kind of the change and the protections and the rights and how the elections work and that kind of thing is again if you're an employer who traditionally has been outside of this space or bubble where organizing efforts typically have not occurred. You're small enough where you think that would never happen because there's direct line to ownership, and I think that's probably more commonly a reason why there isn't a need for unions in smaller businesses. Like something has happened, something has shifted, and even in those spaces now this is occurring. So, and that's where a lot of the traction is, I think. So again, if you're listening and you're in one of those situations and you think this isn't relevant to you, certainly there are many case studies here locally, even in Western New York, where that is proven to be wrong.
For sure.
So the theme of this podcast is typically updating listeners on changes and significant goings on in the employment world. And so one of the things we want to talk about is not just highlighting the increased rate of unionization recently and kind of the expansion of the typical places you see it, but also some of the major regulatory changes that have occurred. And Heather, I know you're an expert in this area, so perfect to have you here for this. But one of the main things is not just that it's becoming more prevalent, but the path to union recognition, once efforts have begun, is easier and shorter than ever. And I think, Heather, you said something like basically once it started, it's over, right?
I mean, the train's left the station, right? If you are starting your response to a union organizing campaign today when you first hear that the employees are wanting to unionize. It's probably too late already to really have any really significant influence on what the outcome of that situation is going to be. There have been just in the last less than a year, there have been two significant changes that have occurred. One was a rulemaking at the National Labor Relations Board, which really um, shortened the time frame for the processing of election petitions. So once the union says we have enough people that have signed cards, we want to have an election, and they file a petition and ask for an election, there's a process that happens. And in the past, that process could have taken a month or 6 weeks or maybe 2 months. It could have, it could have, there are things the parties have to talk about, and there's a period of time between when the petition for the election is filed and when the actual election occurs. And during that period of time, um, there were opportunities for the employer to communicate its views to
Mm-hmm.
employees, or to educate employees about what it means to have a union. Um, that time frame has been significantly compressed now, starting with any petition that's been filed since December 26th of 2023. The time frame is really, really quick. I'll give you an example. I had a petition that was filed on December 29th, 2023. It was the first petition filed under this new framework, and the National Labor Relations Board was looking at having an in-person election on January 12th. That was the day that was first proposed to me for an in-person election. So it's 2 weeks. It's
And
like,
this is the quickie election
yeah, I mean,
reinstatement rule? Yeah.
some commonly referred to that way. But
Yeah.
so the idea, the board's position is that the election should occur as quickly as possible after the cards are signed, because not doing so delays employees in the exercise of their rights. And so they really are moving toward getting the election conducted as quickly as possible. So they've shortened a number of time frames for responses to the petition, time frames for hearings that are going to be held, where the parties cannot agree on things like what jobs belong in or out of the bargaining unit.
Mm.
Um, and so it's all going much quicker now than it used to.
So not a
So
lot of
that's
time to yeah
not a lot of
to
time, not a lot of
to
time. So
change
if
the
you don't,
narrative or yeah yeah.
if you're first hearing about an election when the union files its petition and it comes to you as a complete shock, you really don't have much time to talk about your feelings and in your views to your employees
Mm-hmm.
at all. And
Counterattacking.
quite frankly, we're typically so busy doing other things like educating managers on what they can and can't say,
Yeah, to avoid
um,
those unfair
and
labor
filing
practice charges.
paperwork
Yeah.
and negotiating with the
Yeah.
union and the board about who belongs in the unit, who doesn't, that there's very little time left
Yeah.
for that education piece, even if you wanted to try to do something.
Yeah.
So that's the first piece. The second piece is equally as influential of the process in a different way. Um, so typically in the past, the path to unionization almost always involved an election. The union would get employees to sign cards. Once they had the requisite percentage of cards signed, they would file the petition seeking an election. Now, the union has always been able, under the act, to go to the employer and say, "Hey, we have more than 50% of your employees have signed union cards indicating they want to be represented by the union. We'd like you to voluntarily recognize us. Will you voluntarily recognize us?" That
Mm-hmm.
has always been a path to unionization. It's just one that was never, hardly ever utilized, right? Because most employers, let's be honest, most employers who are not unionized would prefer to stay not unionized. And
Mm-hmm.
so, if given the choice between voluntarily recognizing a union and saying, well, we want to have a vote, most are going to opt for the vote, right? So they're
Yeah.
not going to just voluntarily recognize.
And the union didn't
Even
have to show proof of like the majority, having signed the cards, right? There's really no way to
Well,
substantiate that.
there was a way for that to happen. So you could get a card check. And in the past, the National Labor Relations Board would perform a card check.
Okay.
So the union would provide its signed cards to the board, and you would provide whatever copies of employee signatures you may have on file, and the board would check those and
Mm-hmm.
say yes, this is the bargaining unit and we have more than 50% of people. So the board would give you that. I think the question in employers' minds was, we don't know what was said to the employees when
Yeah.
the card was presented to them. Did the employees understand they were, by signing a card, they were saying, I vote for or I want union election?
Right.
Sometimes employees think this is just to get an election. I'm signing the card just to get an election, regardless of what the card says. The card might even say, this means you want to be represented by union ABC, but
Mm-hmm.
not all employees look at that or understand that. And so I think the employer's position always has been, we would like there to be an election
Yeah.
so
Right.
that we know for sure that our employees understand what they're choosing here. um, so that was typically the way it, we got a union in the past. um, in August of 2023, the National Labor Relations Board issued a decision in a case where they held that really has started to change the landscape of how that happens. And so voluntary recognition of the union is becoming more common. It's becoming almost routine for the union to ask for voluntary recognition, whether or not they think they're going to get it. They always ask for it. And the reason for that is that this National Labor Relations Board, it's the CEMEX case, was issued, and the board says, once the union comes to the employer and says we have 50% plus one of the cards signed and
Mm-hmm.
asks for voluntary recognition, the employer has a couple of choices. They can voluntarily recognize, that's one choice. They can go file their own petition seeking an election. That's another choice.
The employer.
um, or
Okay.
they can or they can wait for the union to file a petition. Um, if the employer doesn't file a petition within 14 days and the union doesn't file a petition and the employer doesn't voluntarily recognize, the board has said that you have refused to bargain with the organization that your employees want to represent them, and you can't just drag it out and let
Mm-hmm.
things sit. You either have to recognize or you have to promptly, and the case law indicates that promptly is within 14 days, file a petition for the election yourself. The other thing that case did was say that, once the union asks for voluntary recognition, if the employer commits almost any what's known as an unfair labor practice, if they do anything that violates the employee's rights during that time, the board, the region, the board could set aside the results of the election and order the employer to bargain with the union, because they say that the unfair labor practice, the conduct of, for example, discriminating against a big union supporter,
Mm-hmm.
um, is it taints the election. It
Yeah.
chills people's activity. And so they say a better representation of what the employees want is the card signed versus
Mm-hmm.
what happens in the election after there's been an opportunity for, unfair labor practices to have been
Yeah.
committed. And so there's a lot of concern now among employers once you get that request for voluntary recognition. Employers used to, the campaigns that they put on to educate their employees about union organizing, um, they're a lot more concerned about what they do and say during those campaigns. They're a lot more
Yeah.
concerned about disciplining any employee for anything once a request
During
for
that time. Yeah.
voluntary recognition has been made, because of the concern that they could have an election where the employees actually vote, no, we don't want a union, and the board could say, well, you committed this one unfair labor practice that tainted the election. We're ordering you to recognize and bargain with the
Yeah.
union. And so it's a quite frankly a very scary time for
But so there's a
employers
lot of
right
traps
now.
set, right? So I think like after, a union rep or someone, the employees come forward and say we have 50% plus one of these cards. If you decide you want to take your chances, do an election, it's like I think one of the quotes in the articles I read was proceeding at your own peril, which
Yes.
is and I think so some significant things out of this, like that 14-day period, right? That significantly shortens the time between you've been put on notice and when you must have the election. And what you're saying, Heather, is if the employer themselves, even in the absence of the union doing it as well, does not have an election within 14 days, that would be considered almost an unfair labor practice charge in itself, because they weren't showing good faith according to the NLRB now, and in conducting an election within an amount of time that the NLRB thinks would be fair. Is that what that
Right. So the
means?
election, to be
Okay.
clear, the election doesn't have to be conducted within 14 days of the request for voluntary recognition. The petition to get an
To do
election
an
has to
election,
be
yeah.
filed.
Okay.
The
Okay.
employer has to either recognize the union or say, we're not going to voluntarily recognize you, but here, let's have an election. Let's and
In
get the
14.
process for the
Okay.
election moving. Another thing I've seen happening is that oftentimes, just to speed things up a little, unions will often request voluntary recognition and file a petition for an election on the same day. I've seen that
Okay.
happen as well.
Yeah.
So
And now
now
with that quickie rule, the election has to be within 8-ish days, 2 weeks of
it's
the
good. I mean, once
filing,
the
right?
petition gets
So,
filed, there's a
yeah.
quick time. There's a quick
Yeah.
time for filing the response, and the National Labor Relations Board is going to keep chugging along. You can still voluntarily recognize if you choose to do that, but you thinking about whether you want to voluntarily recognize the union for a week or two, that before the petition gets filed, that doesn't happen once the union files its if the union files its petition right away
Okay.
with its request for voluntary recognition.
Yeah, and I think another important point to make, that this, obviously the ante is upped in that, like, now the president has been set that if there is any sort of unfair labor practice charge committed during this time, um, that may result in automatic recognition, right? So that itself is
An
concerning.
order that you recognize, yeah. I mean,
Yeah.
so we're waiting on that. I will
Okay.
say, like, that's what the National Labor Relations Board has said. Ultimately, it is the legislature and the Supreme Court of the United States who get to have the
Okay.
ultimate say on that. So it's
Those
too
guys are
soon
busy.
right now to see
Okay.
whether the board's rule is going to be upheld or
Okay.
not, but I'm certain it's going to be. I'm certain that there are going to be appeals taken. When that bargaining order is issued, there will be appeals taken to the federal courts and ultimately to the Supreme Court. I mean, prior to the board issuing this decision, there was a Supreme Court decision many years ago about when a bargaining order could be issued, and it requires significantly worse conduct on the part of the
Yeah.
employer than what the board is saying now.
Okay.
So, I mean, I'm telling you what the board is saying and what you're going to be faced with if you're in that situation.
Yeah.
You certainly would have the right to appeal those things, but I think, I mean, the goal for most employers is to stay out of the situation
Yeah.
entirely so that you
Just,
don't have to
yeah.
appeal
Other
it.
things to deal with and pay lawyers to do. And we like
That's
lawyers,
right.
Heather, but we would rather, I'm sure everyone
Spend
would
your
rather
money on
not do
something
that.
else.
But yeah,
Yeah.
so on that point, like, just want to elaborate slightly on, we kind of talked about it already. Even if you're not, in the midst of an organizing campaign, or you're not unionized, these unfair labor practice charges can be filed against you as an employer. But they're much more significant to occur during this time. But I want to make the point of, like, what that includes, right? So we've talked about, like, telling employees they can't share or talk about, information about pay, right? Complaining and commiserating about, like, how they feel about their managers or supervisors or ownership. Any working conditions, right? Safety conditions, environmental conditions, but also things like, I think this is really common, and I hear this too. I mean, it's kind of human nature, but employers who initial reaction to maybe organizing efforts, or even before they come in, is, making a comment like, if that happens here, we're shutting down the business, right? Like threats, things that are
That's a
even
threat.
like thinly veiled threats. And I think those things are considered more of a threat than ever, right? And certainly are going to get you in hot water more than ever.
Yeah, so those are the types, that's the type of conduct that we're typically dealing with, or those are types of allegations that we're typically dealing with
Right.
in the context of a union organizing campaign. So there's a few things. The employer made threats about what would happen if the union came in. You'll never see another raise in your lives. I'll close
Mm-hmm.
the doors. I'll fire you all. All the
Right.
union supporters will be gone. Um, also just discriminatorily treating people who are active
A part
in
of,
the
yeah.
union organizing. So going out and firing the person that is is a known leader in the union, or the person that kind of brought the union in. Um, Doing other things that interfere with the employees' rights that will tend to chill their activity. So like instituting new rules that
Mm-hmm.
are intended to crack down on
Scare people. Yeah.
scare people.
Yeah.
Um, Very innocent things too in some ways. So you're not allowed to surveil your employees in their union activities. And so we've had cases where an uneducated supervisor, and when I say uneducated, I mean uneducated in the National Labor Relations
Sure.
Act and the
Sure.
law, um, says something may mean nothing by it. They're not intending to imply that they're watching what's going on with the union activity. They may even be talking to people that they've typically had a friendly relationship with. And they say, so what is it? Like, who started all this union organizing? Like, where did this come from? They're just, they're curious.
Right.
And that any supervisor who says or does anything is deemed to be, the agent of the employer. And so your supervisors, it's
Yeah.
really important to educate them right away when you have a union organizing campaign going on, educate them about what they can and cannot do. And we typically say, look, you can listen to employees all you want. They can come to you and talk to you about their feelings, but you shouldn't ask them any questions about what's going on with the union organizing. You don't want to know who supports the union, who doesn't support the union, who started the union. You don't want to know what was talked about at their union meeting last night. You don't want to know who attended those meetings. You don't want to know what is it that you're looking to get from having a union. You just
Yeah.
don't want to ask any questions. So if they come to you and say, wow, this is great, we've got this union thing going on, blah blah blah, you just smile
Yeah.
and nod and yep yep. I mean, really, just the less they
Yeah.
say the better, because we see a lot of unfair labor practice charges that involve those types of very innocent
Yeah.
interactions
Yeah,
with
because the
employees.
perception will be that that information is being sought or solicited for nefarious, evil reasons, and
That's right.
you
You're going to
just
go
don't want to
back
have
and
to
tell the
defend.
employer,
Yeah.
and yeah, and then you're going to go retaliate against these people
Right.
for their support for the union. And so those are really the types of activity that we see.
Okay.
um
Yeah, and I think that was the other point I was going to make, which you did cover, like we've talked about several times on this podcast, and I talk with clients about all the time. And it's not just your conduct as a business owner or someone who has equity or shares in a business or something that matters when it comes to this or any type of employment law charge, we'll call it, or claim. It's anyone who is an agent of the organization, which is basically anybody who's in any sort of people leadership or management role. Their conduct is your conduct. So something that they just innocently don't know about that they shouldn't say, or something that, again, yeah, maybe it is actually innocent and it's in reality and they're just having a conversation. Their actions are your actions. So that, the bigger you are and the more people you have in those roles, the more seriously you should take this episode and all of them, because the more opportunity for mistakes and innocent risks
yeah,
and issues to occur. Yeah.
yeah. And so that's why typically, like, one of the first things that we do when we find out that there's union organizing going on is say, get all your managers together so we can
Yeah.
tell them what the do's and don'ts are, so that they don't cross the line. And I mean, we've had situations where that training got delayed by a day or 2 days, and you have one manager go out and
Yeah.
he or she doesn't
Yeah.
realize the implications, and it's not intuitive. It's not something that you would just sort of know. It's not necessarily a common sense type of thing.
Mm-hmm.
People, unless you've been educated in the area of the law, you would not suspect
Yeah.
that just asking a question with, like, how was your union meeting last night, could
Right.
get you in such trouble.
Yeah. Yeah, so again, the point being that, this stuff was important before, certainly, but now the stakes are higher because making missteps, even rolling out like a policy change that you were planning to do before the election and now you do it after the election, that could be an unfair labor practice charge. These comments could be
Yeah.
unfair labor practice charges. It was a pain in the butt to have to defend an unfair labor practice charge before, outside of an election, or even during it, but now doing it could result in automatic recognition also, and um, completely undermine, yeah, any efforts you or chance you have in winning the election as the employer.
Yeah, the
So
stakes are just so much
yeah.
higher
And
now.
then one other thing I just wanted to make sure we hit, Heather. So not that there's really time to do anything anymore between the time that you're notified of organizing efforts and when an election may need to occur. But even if there was, in New York State where we are, and I know other states are doing this as well, you actually are no longer allowed to require employees to attend meetings that you may have where you want to educate them on the counter narrative, or the downside to unionization, right? The captive audience meetings are now illegal in New York State.
Yeah, so that's a recent law that was passed by the state that says that you can't require employees to stay at these meetings where you're talking about political, and they include union activity, political or religious beliefs to employees in the workplace. We'll see where that goes. We'll see if that law, and I will say the general counsel at the National Labor Relations Board, she too is saying that captive audience meetings are unlawful. I don't know that that's going to stand. I mean, employers have a First Amendment right, just like the rest of us in this country,
For now.
to, express their opinions and their views, right? So having that law might be a law such as that is likely going to be seen as violating the First Amendment. I mean, it will certainly get you in trouble. Right now, you'll be violating the state law. The National Labor Relations Board will take the position that you've committed another unfair labor practice charge if you do that. But I do think ultimately there'll be that will go up on appeal too, and we'll see what the Supreme Court does with that.
Mm-hmm.
Um, what I will say is that you can still have the meetings. You just, if people decide they're going to leave, walk away, I'm not staying for this, I don't want to hear this, there's nothing you can do about that. You can't require them. So you can still communicate the information to
Okay.
the extent that you wish to do so. And my recommendation would be that you have everything that you're going to be communicating vetted twice, and really
Yeah.
like make sure that you're not saying anything that could even be perceived as threatening or perceived as interfering with people's rights. But you can still communicate the information. You just can't force people to listen to it
Okay.
in a group
Yeah,
setting
and
like
that and
that.
that's a good point too. If you hear whispers of this in your organization, instantly call a law firm like Heather's because
Yeah, I
you
mean, you
cannot
just
do this
you
alone.
yeah, it's not, there are a lot of areas of the law that things kind of make sense, and it's reasonable, and a reasonable person would know or understand that. This is not one of those areas of the law. It's
Yeah.
definitely things that, most everyday people would think are not problematic,
Yeah.
that could get you in big trouble.
Yes, yes. I often have conversations with people who are not aware in the details or nuance of these things, and they think I'm absolutely crazy, but it's real. Um,
Yeah.
all right, so we've kind of inundated everyone and probably overwhelmed them with information here on updates to the laws and rights and that kind of thing, but all really good stuff. And this is high level, so certainly if you guys are interested in learning more, you should probably call an attorney to talk with them about it if you have something going on in your organization that's the reason your interest is piqued on this, but you certainly can read more about it through different Googling and sources and things like that. But want to make sure that not only are we sharing the information with you, but kind of the why behind it and making it practical and having actionable takeaways. So one thing I do want to talk about is just kind of why this is significant for businesses and the implications of, like, we obviously know and we've talked about how they're like the implications of even inadvertently violating some of these rules and rights, the unfair labor practice charges, which at the very least just cost you a lot of time and money to defend with a lawyer. At the very
Yeah.
worst may result in a union being recognized if it's during an organizing campaign. But certainly, and the next thing we're going to get into, I think, is how you can take some measures as an employer to be an employer that has a good enough relationship and rapport and trust with staff so they don't feel like they need to have this representation. But if a union does enter your organization, there are certainly it changes the organization forever. I think that's undeniable. And we're not necessarily saying for better or for worse, but it just changes the dynamic forever. And that has to do with things like labor costs. Obviously, I think the stat here, the cost for a private industry worker versus union versus non-union is like a difference of 40% in total comp, right? So benefits, hourly pay, that kind of thing. That's not a small amount of money. I mean, most businesses certainly don't have an extra 40% in their margins, laying around to have absorbed into that. So it's important to get this stuff right and maybe do the right thing to prevent this from happening for that reason. But also the culture shift that occurs. The relationship between the employees and the employer directly fades away, right? Nothing. I think you've made this point quite often, Heather. Really nothing can be discussed, negotiated, or agreed to without collective bargaining at that point, right? When union's in place and negotiated.
Yeah, so you need to involve the union in those conversations. So a lot of employers are like, well, yeah, we have these rules, but we're a compassionate employer. We care about our employees. We make exceptions to those rules, and
Yeah.
when it's appropriate, and that's great. It's great to be able to have that flexibility to do that. But once you have a union in the workplace, that flexibility is limited. That's not to say that you can't make an exception to the rule, but doing so is going to require not that you just have a conversation with the employee about it, but that you have a conversation with the union about it, and you get the union to
Bureaucracy.
buy
Yeah.
into it, and
Yeah.
you get a memorandum of agreement in place that says this is for this special reason, and that it won't be deemed a part of our practice, and it can't be used in any other case against us, because the first thing that happens is when you go to discipline someone for something, the, you have to have just cause to discipline or discharge employees. Typically when you have a union, you can't just say, like, I am so sick of this person's attitude, I'm firing them, I don't want to deal
Employment
with
at
them
will.
anymore.
Yeah. Yeah.
Yeah, it's not, you don't have employment at will anymore. You have to demonstrate typically that there was a rule, that they violated it, that they were on notice, that you progressively disciplined them and they didn't improve, and that really that the discipline was warranted. And I think, as is common in many, especially smaller businesses, like, you're busy doing other things. You're not documenting disciplinary actions all the time. While you should be, you may not be keeping those types of records. And
Never
so
as
you
much as
may
we
have
want
that.
them to be.
No, we want them to document everything. And, they tell me it's not possible. And I would be spending my whole day documenting things. And it's like, once you have a union, you kind of have to do that. You kind of
Yeah.
have to start really keeping better records, so that you're treating like situations like. And
Right.
anytime you make an exception, that could be used against you. And even making an exception that benefits someone, the union could claim that you're undermining them, that you're
Right.
giving a benefit without bargaining with them. So
Yeah.
it's just all of that. I mean, I once had a situation where a client wanted to give bonuses to employees. They had a great year. They wanted to give bonuses to employees, including union employees. The client wanted the ability to determine the amount of the bonus based on a number of factors, and the union wouldn't agree to that. They wanted everyone to get the same amount regardless. They didn't want any, performance evaluation
Mm.
or whatever to be
Merit
taken into
based.
account.
Yeah.
And so the whole union wound up not getting bonuses, because the company was not going to do it that way.
Yeah.
They wanted to give bonuses based on, good performance, and employees who had really contributed to the organization. And so,
Yeah.
I mean, even to do something good, you have to talk to the union about it.
Yeah. Yeah, I think that's an important point. And again, we're not making a case for or against unions being good or bad for companies, but it's not as black and white, I think, as some of the more recent narrative out there, and that it's always a win for the employees and always, kind of a win against,
Hmm.
or, a loss for the employers. I mean, there's certainly are many situations where I don't think that that's the case. And you're paying union dues as an employee now, and whether or not that's getting you more rights, or not rights, but pay or benefits or whatever it is you're looking for, is not a guarantee. But you are paying that, and you are kind of losing we both work, I think, typically with smaller employers and smaller businesses, Heather. And I do think like that is such a the culture in a small business is usually so much better and different, and usually what employees are looking for, right? Like you have
Yeah.
that direct relationship, you can have flexibility in your work schedule, they give you, a personal leave of absence that may not qualify for one of the many reasons that leaves are out there for. They give you an extra couple $100 in your check 1 week because you're going through difficulties at home. Like these are really great, nice things that yeah, introducing such formal relationships in with a union and bargaining and things really kind of eliminate. So just something to consider, in the whole mix of things, but not as black and white, I think, as people may think sometimes.
Yeah.
Yeah. All right, so let's talk about takeaways, the main takeaways of this, because this is a lot of information. If you made it this far, fantastic. Just listen to this far and you have your takeaways. But basically, the two main points that really Heather and I wanted to cover today are one, these efforts start really small and it's smaller than ever. So, like we said, this is happening in smaller businesses than more than ever before. It's happening in industries that it hasn't happened in than ever before. And on top of that, one point we did not cover is how small a bargaining unit can be, right? So even if your whole organization is not unionized or isn't going through this campaign, it can start in one tiny little bargaining unit within your company of just similarly situated employees. And I think that's just like maybe one or two employees it can start with, right, Heather?
Two. I mean,
Two.
for concerted activity, you need two people. It can't be
Yeah.
one person, but two people. And you could have a potentially have a union. And I've seen it over the years. It used to be like the entire workplace or the entire like all of the manufacturing plant. And now the unions they recognize that they may have more support in certain areas than in others. So they're um, they're petitioning for smaller units, micro units, let's say. So they
Mm-hmm.
don't want the field service techs that go out to the customers and install equipment. They just want the people in the manufacturing plant because they know they don't have the support necessarily of the field service tech, so they may
Mm-hmm.
not want them. I have a unit now that I think when they initially started organizing, they were looking at, it's in the hospitality industry, and they were looking at organizing the front of the house people, servers, as well as the back of the house cooks and people in the kitchen. And they wound up seeking to represent only the servers because there was no support for them in the kitchen
Back.
staff.
Yeah.
And so, while that maybe is helpful to the employer in some ways because you have a smaller number of your employees unionized, um, once they start there in that small
Right.
area, that there's the potential for that to grow over the years. And
Yeah.
so we are seeing, I will say, that they are petitioning for really more defined units.
Yeah, because it's a starting point, right? Right. Yeah.
Yeah.
So smaller starting points in the bargaining units and smaller time frames for the elections and smaller like ability, I guess, smaller rights for the employer, we'll say. So all very valid points, and again, just emphasizing how easy it is now for this to kind of get going, and with just a tiny little spark, and once it does, kind of hard to stop. Um, and then, yeah, the other point being once it starts, it's definitely too late to do anything at this point for all those reasons we discussed. You know,
Yeah. So, I mean, I think what I would say there is that, do what you can now to educate at least your management staff, your supervisors and your management. Do what you can to educate them
okay.
in a number of areas. So I've had cases where I've talked to managers in the midst of the campaign or follow up dealing with unfair labor practice charges. And they're like, oh, yeah, they've been talking about the union for weeks. They've been talking about the union here. They were talking about the union there. And but yet when the head of the company got the request for voluntary recognition or when the petition arrived, it was the first they were hearing about it.
Yeah.
So if you have supervisors, it would be nice for them to let you know if they know that there's organizing activity going on,
Yeah.
so that you can at least get prepared. You can start training them on what they can and can't do.
Yeah.
And if you want to do an education program for your employees, you can start like getting that prepared and getting that underway, because once the petition is filed or once the request for voluntary recognition is made, there's just really not time for a lot of
Yeah.
that.
Yeah, and I saw a statistic that elections, basically once it starts, unions are winning at an 80% plus rate now, which is like the highest it's ever been in 20
Yeah.
years. So that's, again, right there, just facts for you if you don't believe it. But yeah, I think being proactive, even if you don't even have any concerns about it at all, but you're in an industry that is kind of on this list of those that are highly active in this way right now, doing a training with your supervisors and managers. Because I think another point that's important to make is supervisors and managers cannot be in the union. So some people may think, well, why would I want to introduce this concept or this idea of organizing into my business if it's not happening, right? Am I just then like asking for trouble? But those individuals cannot be a part of the bargaining units, right, Heather? And they cannot organize. So if you're isolating it to that group, which you would, because those are the ones that need to know what to look for and what to report and how to respond or not to respond, that should be okay, and you should be safe doing so. Yeah.
Yeah, that's correct. Supervisors are excluded from bargaining units, provided that they actually are supervisors. And as the employer, you can demand a duty of loyalty from them. You can
Yeah.
demand that they be loyal to your cause. And so, to the extent that they're not going to support you in that regard, you don't have to employ them.
Mm. Yes, that's good. And they should support you. I have that conversation with my clients all the time. And whether it's like supervisors and managers knowing about this stuff or knowing about like sexual harassment that is occurring or, other things that are
Mhm.
going on that shouldn't, their loyalty has to be first and foremost to you, the business, and not to their employee friends because
And they have an
it,
obligation. They have
right,
a legal
liability.
obligation
Yeah.
to stop sexual harassment and things like
Right.
that. So yeah, absolutely. I mean, I think that's one area where businesses can do better with their managers is like really, making them understand like as a manager, as a supervisor, what does that mean legally for them? They can be sued personally under some of those statutes.
Yeah.
I mean, they could personally be sued if they don't act,
Yeah.
even just for doing nothing. They don't have to be engaged in the bad conduct, but knowing about it and ignoring it can create liability not only for the organization but for them personally.
Yeah. Good to know. Yeah. I think not. Kind of a lot of these topics and episodes go back to that all the time, your managers and frontline supervisors, because they're the ones that have the greatest ability to impact your organization positively or negatively, and this is just another reason why.
Well, and quite frankly, if a union does come in, if the employees in your business feel that they need a union, it's probably because of the conduct of your managers and
Right.
supervisors. It's probably not because of the business owner.
Yeah.
It is
Yeah.
probably because the way managers and supervisors are communicating, the way they're treating employees, the way they're dealing with employees. And so, another reason that it's important to invest in your managers and
Yeah.
supervisors and in training them and making sure they understand the
Yeah.
significance
Their
of how
role.
their conduct is
Yes.
impacting the bigger picture.
Yeah, and that was kind of our final takeaway is improving the level or the quality of your employee relations and your employee engagement in your organization. And those are kind of nebulous terms for a lot of people I know, which you can certainly break them down into more tangible things. But like your point, Heather, like usually your level of engagement and the way employee relations are dealt with and how positively or negatively that goes is directly correlated with the quality of your supervisors or managers because they're the ones
Hmm.
having those conversations and managing performance and giving feedback and either engaging or offending your employees and improving the quality of that population. I think is the greatest investment you can make in your business, regardless of how many or how few of those people you have. Including with just hiring the right people to begin with and being maybe a little bit more I always want to say discriminatory in that process, but we can't use that word because of what else it means. But
Selective.
yeah, more
Just
selective,
selective.
and just more vigilant, I guess, in that process, right? Like, there's a lot of like soft skill questions you want to ask and like character based questions you want to ask, not just do you have experience leading people, but what is the quality of that experience and what have some of your outcomes been? And do you have references from people that have reported to you previously that can comment on that? Would all be good, but certainly like who you allow to become supervisors or managers in your business is a good place to start. And then if you're looking to invest in skills in an organization, frontline workers, sure, but I think managers and leaders is, again, if you want the biggest ROI, training them on your policies and procedures, how to administer, just educating them straight up on how to administer those things, so they can be consistent, but then also the do's and don'ts legally. Like we said, what is an unfair labor practice charge? What can you discourage people from doing and saying? What can't you? How to deliver performance feedback, that kind of stuff. Yeah.
Yeah, I mean, I think when I start hearing what employees want and what the concerns about employees are, it's like unequal treatment, unfair treatment. Managers are giving certain people preferential treatment and being tougher on other people. They see that it's unfair. They think they need a union to protect them from that. Just managers who are maybe, overworked and burdened, and they've got a lot
Yeah.
going on, and they have other issues on their mind that, the employees don't know they're dealing with in the workplace, and they're short with employees, or they're
Yeah.
rude, or they're, I mean, it happens. People have stressors. Um, but those are the types of things I think that employees, especially today, and especially with younger people that a lot of these organizing campaigns are being led by
Yeah.
certainly younger employees. They want to be respected in the workplace. I read an article, I sent it to you, I think, Emily. It
Yeah.
said they
I know.
wanted to be loved and cherished in the workplace, and I was like, really? I know, but that's what they want. That's the feeling that they want. And so,
Yes.
knowing that, I think if we can do what we can to make them feel that we actually do care about them
Yeah.
personally, that goes a long way.
Yeah, whether you agree with that sentiment or not, I think it's
Yeah.
about decoding that a bit too, because I think it's really just, a lot of it's about perception and experience. So, yeah, I mean, being loved and cherished in your workplace the way your parents might be expected to do that for you, not so reasonable. But I mean, they should feel that in a way, like a lot of it comes back to expectation setting, right? Like, listen, we are a workplace, and so like it's different than a family. It's a team, certainly, but these are things that you should expect from us and we should expect from you, and let's all agree to make good on that. So I think communication and transparency and expectation setting is super important for all those reasons. But yeah, like level setting expectations, but also yeah, again, whether you agree or not, that is what people are looking for, and there's going to be consequences if they don't get it, unfortunately.
Yeah.
Um,
And they talk about transparency a lot. That's the other thing they talk about a lot is transparency. So I certainly do not expect business owners to be 100% transparent about every decision that they make and everything that they're doing. But I think the more transparent you can be and the more information that you can share with employees so that they understand where you're coming from, the better off you will be with respect
yeah,
to, they're not thinking that you're hiding something from them or that you're
yeah.
doing something, you know, uh, that you shouldn't be doing.
Yeah. And that does, I think a lot of that comes from the managers and supervisors on the front line, right? So they're the
Hmm.
ones that should be relaying up information about complaints or frustrations or desires. But some final things to close with, doing a monthly survey to gauge, not just engagement but specific feedback, what people might like, what they don't like, what you could change. Finding different ways to, explicitly show that you do care, you are interested in getting feedback. But then I think most importantly, doing something with that, because the worse than not getting feedback at all is getting feedback and doing nothing with it. If you want to
Yeah.
build resentment and a lack of trust, that's certainly a good way to do that. So don't
Yeah.
do it unless you're going to follow through.
I'd rather have you not do it if you're not going to act on it and do something about it.
Yeah,
Yeah.
exactly. Yeah, yeah. All right. Well, I think that brings us to the end. Anything that we missed, Heather, or we should make sure to point out before we
No, I
go?
think we've covered a lot, and there really is a lot, and um, I just think the most important thing you can do is if you think there's union activity, like reach out, talk to someone
Yeah.
who can kind of get you headed in the right direction and get you on the right course so that um, you're not already losing before the game even begins.
Yeah. 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 Reach out to Heather's firm, certainly, if you have things that are coming up. Again, if you have a sense that this activity is occurring at all. Other employment claims, though, Heather's firm handles as well. Reach out. And then if you're interested in preventative measures on supervisor and manager training or tightening up your practices or feedback mechanisms or whatever, that's more Ally HR Partners deal. So certainly reach out about that too. But thank you so much, Heather. It was nice to have a formal and now recorded conversation with you. We don't have to just do it over drinks anymore by
That's right.
ourselves.
We
All
can
right.
still do it over drinks, though.
Yes, we certainly will. Yes, there's an endless amount of stories to tell. But
That's right.
all right. Well, thank you, everybody, and we'll see you next time. Reach out with any questions, and yeah, thanks again.
Thanks, everyone.